नमस्कार दोस्तों, वेलकम टू माय यूट्यूब चैनल। मैं आज आपको अपने एक गेस्ट से मिलवा रहा हूं जो कि बहुत ही प्रोमिनेंट और नोन पर्सनालिटी हैं, हु इज़ मिस्टर खेम सिंह भाटी। ही वॉज ILI में इंडियन लॉ इंस्टीट्यूट में रजिस्ट्रार थे और आजकल ये सेंट थॉमस कॉलेज में लॉ कॉलेज में एडवाइज़र की पोस्ट पे हैं। आप पहले जो है इंस्टीट्यूट ऑफ कंपनी सेक्रेटरी में डिप्टी डायरेक्टर भी रह चुके हैं और भी बहुत सी इम्पॉर्टेंट पोजीशंस जो है होल्ड इन्होंने की हुई हैं। जैसे ये DU में एग्जीक्यूटिव काउंसिल के मेंबर भी थे और दिल्ली यूनिवर्सिटी में के कोर्ट में भी मेंबर रह चुके हैं। इंटरनेशनल बार एसोसिएशन में लीगल स्पेशलिस्ट थे लंदन में और जिम्बाब्वे में। ये दिल्ली वक्फ बोर्ड के भी चीफ लीगल एडवाइज़र रह चुके हैं। विद दैट नोट आई इंट्रोड्यूस Mr. Khem Singh Bhati. Namaskar, welcome to our channel.
Namaskar. First of all, I compliment Shri Rajesh Aggarwal ji for starting his YouTube channel, and this medium has become very popular to provide education and guidance to the people at large, and particularly for the lawyers and the law students. It's very significant. And most of the students these days, I find, they refer to the YouTube lectures rather than going to the classes. That has definitely been a diversion, but as a matter of fact, the law does need the reference to the books, because by the Google or by the YouTube, all the information, all the case law, they are not available, so people must refer to the law books and the judgments with regard to the cases and the legal profession.
भट्टी साहब, इसी बारे में मैं आपसे एक क्वेश्चन पिक होता है कि आप जब इंडियन लॉ इंस्टीट्यूट में जब वहाँ रजिस्ट्रार थे तो वहाँ की तो लाइब्रेरी बहुत ही रिच लाइब्रेरी थी और पहले जो है बहुत सब वकीलों के पास बहुत बड़ी बड़ी लाइब्रेरी होती थी और उसमें जो है दिखाने के लिए या पढ़ने के लिए रेफरेंस बुक्स भी होती जो कि इंटरनेशनल बुक्स भी होती थी जी। अब आजकल वो बुक कल्चर तो ख़त्म हो गया है और इवन कोर्ट्स में भी जो है अब फाइल को टेक नहीं करते और इवन सुप्रीम कोर्ट भी ये कहती है कि आप डिजिटल मीडिया में और कोर्ट्स में जजेस के सामने भी फाइल एज सच फिजिकल फॉर्म में नहीं आती और डिजिटल फॉर्म में आती है जी। तो आप इन सब इस चेंज को किस तरीके से महसूस करते हैं?
देखिए, इंडियन लॉ इंस्टीट्यूट अपने आप में एक मूर्धन्य संस्था है. It is a rather international organization which has devoted itself to the research in the legal field on the international level, and it is headed by the Honorable Chief Justice of India. He happens to be the ex officio president of this institution, and the professors of the country, most of the professors, those who are eminent professors of the universities, whether it is Delhi University or it is BHU, all they have been the scholars connected with the Indian Law Institute. And the library of the Indian Law Institute is one of the greatest libraries, law libraries of the world, I must say. And even the foreign scholars, foreign judges have also been visiting the library and consulting those books. And I think probably that more than lakhs of the books are there in the stacks of the Indian Law Institute. And many scholars, they are always sitting over there and they conducting research. And once one professor said also the Indian Law Institute is a factory which manufactures the legal scholars. With respect to the now the modern trend, now the Honorable Chief Justice of India is also been advocating that even the lowest courts also, they should encourage the virtual courts, and all matters should be discussed and decided and deliberated and pleaded in the form of digital methodology. Despite that, what I find, what charm and what interest is generated while you are pleading before the judges in person, or the arguments are taking place, or the evidences or the cross-examinations take place, while you do practically, it gives much more charm and information and in-depth study, it's in-depth understanding of the issues. But the digital formation, particularly we have seen during the pandemic recently, this has not allowed the legal system to suffer, and people have handled their matters sitting over in their chambers in the offices, and they have handled the issue, and legal system has continued to be operational. So this is a real advancement. So I feel probably personally that a hybrid system should always prevail. Those who like to go to the court of law and discuss and deliberate with the judges, they should also enjoy that thing. And those who cannot, those who do not like to go, because now the congestion of the jams on the road, that doesn't allow the lawyers to travel. And also because if you are going to the court, you can hardly attend 1 or 2 courts maximum. But while you are attending the course virtually, then you can, sitting at your chamber, sitting in your office, you can attend to all the course. Yes. Not only in India, not only in Delhi, but all over the country you can. That is a very, very magnificent advancement of the digital system. And we have to match with the international standards also now. Because sitting over here, while we can talk on the WhatsApp call to any country, United States, etc., as if we are talking face to face. So that system is definitely very positive advancement and must be utilized by the students. But still, the universities or the law colleges, law institutes, they are still imparting the legal education in the classroom lecture only. Because eye contact with the teacher of the students is very important. If any clarification is to be needed or things are to be analyzed in a proper manner, then face-to-face interaction between the teacher and taught becomes very necessary. Nevertheless, either of the systems, they are not, they are not exclusively meant for the system. Rather, they should be complementary to each other. They should be supplementary to each other. So whatever suits, whatever is convenient, that can be adopted, and thus the legal system must develop and go to the levels of the international standards. That is my
sir. I must say, sir, that during this in YouTube itself, we have many prominent teachers which have come into light, like Khan sir, Ojha sir, Divya Kirti sir. तो उन्होंने भी बिल्कुल जो उनके लेक्चर रूम में नहीं भी हैं, तो उसके अलावा लाखों लोगों के पास रीच किए हैं, और स्टूडेंट्स या नॉन स्टूडेंट्स या इवन घर पे बैठी हुई महिलाएं भी उनकी बातों से बहुत मोटिवेटेड फील करती हैं. इनफैक्ट दिस इज़ ए न्यू डेवलपमेंट विच हैज़ कम इनटू दिस इरा एंड एडवांटेजेस टू द सोसाइटी. सर, मैं आपसे एक क्वेश्चन पूछना ये चाहता हूँ लॉ से रिलेटेड कि सी एवरीथिंग इज़ कोडिफाइड अंडर लॉ, और हर एक प्रॉब्लम का वट एवर प्रॉब्लम विच में अराइज इन ए सिचुएशन विच में बी कंटेम्पलेटेड इन ए सिचुएशन, दैट इज़ प्रोवाइडेड, आंसर इज़ प्रोवाइडेड इन द लॉ बुक्स. तो उसके बावजूद भी सी वाई देर इज़ ए डिले इन द सिस्टम, रेदर बाय कंप्यूटराइजेशन, बाय ए क्लिक ऑफ बटन वन शुड गेट ए जजमेंट, बट दैट इज़ नॉट द पोजिशन. So how do you say that how to speedify and expedite this legal system?
Very right, Aggarwal sahab. What you said is already under the consideration with the legal system, legal administrators, and even the Chief Justice of India, Dr. DY Chandrachud ji, recently he announced, and it was praised by the Prime Minister Modi also, that the judgments of the Supreme Court for the last decades, several decades, they have all been digitalized, and people can access those judgments by only click of the button of the computer. So that is going on, and the Supreme Court, of course, is here, and High Courts also have done remarkably well. And I must say, Justice Murlidhar, Justice Rajesh Aggarwal, these people, they have contributed a lot towards the digitalization of this thing under the dynamic leadership of Dr. DY Chandrachud ji. And I hope that the judiciary at the lower level, that is the trial courts, they will also pick up the thread, and most of them in Delhi particularly, they have started using it, and they are allowing the lawyers, they are allowing the clients also and litigants also to come and speak to the judges, and judges are taking cognizance of it, and also it is speeding the things. And the time will only testify whether this system, digitalization of the legal administration, whether it's going to help into the removal of the colossal pendency of the cases in the courts. India is suffering. One of the major problems of the Indian courts is that the decisions are taking decades and decades together. Only the other day I saw a man has been granted bail by the Honorable Supreme Court after 40 years when he reached the age of 75, and still the trial has to go on. So hopefully with the digitalization system, I think there should be in certain acts they have given also within 90 days it should be disposed of, particularly consumer law like. But it has not been possible. Even the consumer courts, they are taking 5 years, 6 years to dispose of the matter. So that may probably help out, provided a due publicity and due mechanism and administrative regulation is placed in practice, so that courts also observe it, litigants and lawyers all observe it, and the issues are settled within the time frame prescribed, so that the justice delayed the justice denied.
वो तो बात है, सीपीसी में भी बहुत सारी अमेंडमेंट हुई हैं, उसमें डिले को कर्टेल करने के लिए कमर्शियल कोर्ट्स एक्ट आए हैं, और एक वो सारा सिस्टम अल्टरनेटिव डिस्प्यूट रेजोल्यूशन है. विल नॉट सर मेक इट दिस वीडियो मच लॉन्ग बिकॉज वी हैव ए सेकंड पार्ट आल्सो मे बी सब्सिक्वेंटली, बट आई हैव 2 क्वेश्चंस. आपने अभी जस्टिस मुरलीधर का नाम लिया, मेरे को ध्यान है वो ILI में भी लाइफ मेंबर थे, बिकॉज आई वाज आल्सो लाइफ मेंबर, एंड ही वाज टीचिंग yes, and he contested election for the member, and I also contested election for the same post. This much I remember. एंड क्योंकि वहाँ पे एक मेंबर भी इलेक्ट होना भी अपने आप में एक बहुत प्रेस्टिजियस बात होती थी. तो बट देन he was subsequently elevated as a judge. He was advocate on record. Subsequently I also became advocate on record. Therefore he is an inspiration to me, and is a very upright and intelligent judge. अब उनका फिर वो then finally
he is an
ideal person, and he was, I remember he was contesting for this gas victims. So I quoted from his judgment, his pleadings also only a matter, and he appreciated that. But मैं उनके बारे में ये बात पूछना चाह रहा हूँ कि जैसे अभी सुनने में आया, न्यूज़ आई थी कि जी वही he could not be elevated to Supreme Court, and उसमें कोई some is there any politics applicable here available which may impact a career of a judge? How do you say that, how much is the interference of political judicial politics? There may be an executive politics that is not there, but is there a possibility of a judicial political things for the common person do have that impression? I want that you should dispel that.
Very, very important and very burning question is raised by you, Aggarwal Sahab. The Constitution provided the mechanism of independent judiciary, independent executive, independent legislature. Unfortunately, the legislature has been given more importance by the society, particularly the media, as compared to the attention given by the judiciary or to the executive. Newspapers are carrying, most of the papers are covered by the political news. Hardly any news come which relates to the judicial system or other social reforms or anything else. So that imbalance in the three wings of the constitutional mechanism is causing a problem. The other day, the Honorable Chief Justice is on record that he had recommended names of 70 persons to be elevated as High Court judges. And those names are still pending for months together with the Ministry of Law and Justice. So,
now Justice Sanjay Kishan Kaul has made certain direction that they should be done within a particular time frame.
Yes. Unfortunately, the executive power should cooperate with the system. There is always a controversy about the collegium system. The collegium system, as the Chief Justice also says, other judges also say, at present the system which is meant for appointment of the judges is the collegium system. Unless that system is replaced, that system has to be honored. The government should appoint the judges that are recommended by the judiciary, and I feel very, very sad also why the judiciary cannot call the executive to the court and ask for why this delay has been taking place. People of the country, they are looking up to the judiciary for remedy, for the relief. When the Supreme Court itself feels that they are helpless to appoint their own judges, then it is a very pathetic situation. Let judiciary take initiative. They should ask why such a delay, what are the reasons. And the judges are not sufficient in the number. Cases are every day increasing in leaps and bounds. People are very, very aware now about their legal rights. They are going to the court. So we have to come up with a system that all the institutions which have to govern the governance of the country, they should work in total coordination. Rather than one should feel superior, the other should be shown inferiority. So that system. So I suppose, as regards Dr. Murlidhar, I have seen many nice judges. I have had the privilege of serving 16 Supreme Court Chief Justices when I was registrar in the Law Institute. And I have seen the magnanimity of their wisdom, their behavior, their conduct, and I feel probably they are the real human beings, those who are looking up everything very, very dispassionately, ideally, humanly. And Dr. Murlidhar is one of those judges the country had the privilege to have, who has been very upright, who has been very, very human. Everything. I had also appeared a few times before him. Even when I was also having some deficiency in my matter, then he said to me very sternly also and politely, Mr. Bhati, you have to do this thing, otherwise you will suffer. That is kind of judges, and his not being elevated to the Honorable Supreme Court is real loss to the judicial system of the country. Such upright judges must be given due care and due placement what they deserve. What can be extraneous reasons? They should be kept apart.
Sir, one more thing I want to highlight and question you for your wisdom on that about the judicial discretion. The element of judicial discretion is there, and क्रिमिनल सिस्टम में तो लॉ में तो ये बहुत आ रहा है कि जी मिनिमम इतना सेंटेंस देना चाहिए सो एज टू एलिमिनेट दैट डिस्क्रिशन ऑफ अवॉर्डिंग पनिशमेंट, so that minimum 5 years, minimum 7 years, minimum 3 years, that provision is there. But when it comes to the question of granting stay, grant of exemption from deposit of payments, I mean all these things, a wide discretion. So therefore a judgment, जिसे बोलते हैं फॉरम हंटिंग, तो फॉरम हंटिंग के लिए आदमी, कॉमन आदमी सोचता है कि जी ये मुकदमा अब लगाया जाए जब ये रोस्टर हो, या आई मीन सो देयरफॉर व्हाट इज योर टेक ऑन दैट?
And it's I must say that I had the privilege of working with the Honorable Mr. Justice Ashok Desai, who was the Chief Justice of Uttaranchal High Court. He was member of the Governing Council of the Indian Law Institute. I was registrar, so I had occasion to interact with him very closely. He had written a book titled as Justice versus Justices. जो अग्रवाल साहब आपने सवाल उठाया है, that he touched.
The nomenclature itself is very catchy.
Very clear. He wanted to say the discretion of the judges should be based on logic and justice. Whether he should travel beyond the provisions of the law, that is of course a questionable thing. You said the punishment is prescribed by the law. The discretion remains with the judge. What should be the quantum of the punishment? Rahul Gandhi spoke something defamatory, and he was awarded punishment to the maximum extent. Here the wisdom has to be examined. Whether the accused should be given the maximum punishment or all the accused are given maximum punishments.
Yes, that is the question which is to be seen.
Here the judges have to show their independence and judicial integrity.
Right, sir, that is correct. Sir, one more vital question which is now very prominently arising is the imposition of cost is discretion available to the judge. अब कॉस्ट तो चलो ठीक है कि that should be compensatory cost, that should be 35, section 35 is there, section 35B is there, section 35A is there. पर अब जो है कई जजेस मैंने देखा है कि जी this much amount you deposit with such and such institution, with you आप 10 दिन तक गुरुद्वारा कमेटी में ये आप काम कीजिए, आप 48,000 जो है वर्दी यूनिफॉर्म दे दीजिए पुलिस को. अभी ये रिसेंट जजमेंट था एक कोर्ट का. ऐसे जो इतने प्लांट्स ट्री प्लांटेशन कर दीजिए. वेदर सच काइंड ऑफ डायरेक्शंस, discretionary directions which are not contemplated under the law. These charitable programs can always be done by the accused at his hometown himself or voluntarily. Can it be such an order is a legal order? Can or it should be, see logically speaking कोई उसको क्वेश्चन नहीं कर रहा क्योंकि चलो जी कुछ समाज के लिए भलाई हो रहा है, और वो दूसरा आदमी भी सोच रहा है चलो मेरी FIR क्रैश हो रही है, मेरे को ये 50-60 हज़ार का काम करना भी पड़ जाएगा या मेरे को 10 दिन के लिए जाना भी पड़ जाएगा, तो मैं चलो गुरुद्वारे में चला जाऊँगा या मंदिर में चला जाऊँगा ये काम कर लूँगा. That may be different thing. But as a legal person, are these orders are not extra legal in nature which should not be passed by the judges?
And this is what is the question arises is whether judges should travel beyond the provisions of the law. When a particular section has prescribed a particular punishment in that form, in terms of money or in terms of imprisonment, like the constitutional courts should observe that provision within the framework of the law. If discretion is so used, any judge can give a direction which is uncharitable.
तो अपनी इनर कॉन्शियस को सेटिस्फाई करने लीगल सेटिस्फैक्शन तो नहीं है इसमें, अपना इनर है. अब एक कोई था कि जी वो आर्मी वेलफेयर विडो एसोसिएशन को आप इतने पैसे जमा कराइए. नो, क्वांटम इज वन इशू एंड द रेसिपिएंट ऑफ दैट कॉस्ट इज अनदर इशू. So there should be certain regulation. To my mind, it should be यूनिवर्सली फॉलो कि प्राइम मिनिस्टर रिलीफ फंड में इतने पैसे जमा कर दो. Why is it judges want to register their names in Prime Minister Fund or these institutions? That is a question. So, what is your take on
that? That is a very wrong trend as such. Judges should not use the distinction which is not palatable to the society, which is not ideal, which is only biased. As you said very rightly कि भाई आप अपनी पर्सनल ईगो को सेटिस्फाई करने के लिए या अखबारों में नाम छपवाने के लिए यू आर नॉट ए पॉलिटिकल फिगर टू गेट द पब्लिसिटी थ्रू मीडिया. आपको जो कानून के प्रावधान है उसके अंतर्गत ही तो रहना है. अब चूंकि आप कॉन्स्टिट्यूशनल कोर्ट है तो कोई कुछ कहेगा नहीं. छोटी अदालत से अगर कोई ऐसी बात हो जाएगी तो 10 सवाल पैदा होंगे.
सर लास्टली मैं सिर्फ टू कंक्लूड मैं आपसे सिर्फ यही बात पूछना चाहूँगा कि अभी यंग जनरेशन जो न्यू लॉ एंट्रेंट्स है या स्टूडेंट लाइफ में ही अभी पढ़ रहे हैं 5th ईयर में 4th ईयर में इंटर्नशिप कर रहे हैं, तो आजकल मैंने देखा है कि बच्चे तो बहुत ज़्यादा दे हैव डिफरेंट थॉट्स और बहुत ही लीगल उनका जो है कंसेप्ट इज़ ग्रोइंग कंसेप्ट. And we hope that they should bring a change in the society. But what is your suggestion? What is your guidance to them through this channel?
सब देखिए बड़ा दुखद पक्ष है. Legal institutions have been set up by the universities. Mushroomed. ऐसा देखा जा रहा है कि जिन विद्यालयों में ना तो जगह है, ना लाइब्रेरी है, ना क्लासरूम्स हैं, ना टीचर्स हैं, ना बुक्स हैं, वहाँ पर एडमिशन करके बार काउंसिल ऑफ इंडिया हैज गिवन रिकग्निशन टू सच इंस्टीट्यूशंस. व्हाट काइंड ऑफ लॉ दे विल प्रोड्यूस? आज ये कहा जाता है कि इट इज डिफिकल्ट टू फेल इन लॉ. उसका रीजन यही है कि एग्जामिनर्स के पास कॉपी जाती है, बच्चे कुछ भी लिखाते हैं, वो उसके साइज देखकर नंबर दे देता है. कई बार अदालतों में देखा गया कि जज साहब पूछते हैं कि भाई आपने लॉ किया है क्या, आप LLB को लिख कर बताइए आपके.
सर वो तो आजकल बहुत सारे जजेस को भी सुपीरियर जजेस ने कह दिया कि इनको दोबारा ट्रेनिंग पे भेजो व्हेन दे डू नॉट पास गुड जजमेंट. वो तो एक बात है ही, दैट इज एवरीवेयर. बट फिर भी मैं समझता हूँ जैसे आज लोग आजकल क्या है कि लॉ की स्टडीज़ भी जो है काफ़ी महंगी हो गई हैं. जैसे अच्छे कॉलेजेस भी आए हैं और प्रैक्टिकल नॉलेज भी अब इन लोगों को बच्चों को ज़्यादा हो रही है, क्योंकि शुरू में 2nd 3rd ईयर में इनको किसी लॉयर के पास इंटर्नशिप करने के लिए बोलते हैं और दे आर यूटिलाइजिंग द कोर्ट क्राफ्ट ऑल्सो दे आर सीइंग. सो टू सम एक्सटेंट अच्छा जो वो अनएथिकल बच्चे मेरे को नहीं लगता कि अब ऐसे इस माहौल से निकल के आ रहे हैं. कोई मतलब एक्सेप्शंस आर एवरीवेयर बट स्टिल मेजॉरिटी ऑफ द पीपल जब बहुत सारी गर्ल स्टूडेंट्स आ रही हैं, सिस्टम हैज़ अपग्रेडेड इटसेल्फ इन दीज टर्म्स. सो देयरफॉर मैं तो ये कहना चाह रहा हूँ कि गुड विशेस टू दोज पीपल. सारा अब नेक्स्ट जनरेशन के ऊपर अब अपनी कंट्री को के ऊपर भार संभालने का टाइम आ गया है एंड दे शुड डू टू द बेस्ट ऑफ देयर नॉलेज एंड एक्सपर्टाइज.
बहुत अच्छी बात कही आपने. मैं सिर्फ इसमें ये एक बात रखता हूँ, बच्चा जब लॉ करके कोर्ट में आता है तो उसके पास एक पैसे का काम नहीं होता. साल तक, 2 साल तक, 3 साल तक तो वो ही इज नॉट एबल टू अर्न एनीथिंग. अपनी जेब से उसके पेरेंट्स के आने जाने का खर्चा और खाने पीने का खर्चा वगैरह देता है. Colleges produce number of lawyers and there is no space for absorption in the judicial system for those lawyers. Supply is much more than the demand. अब हमको ये चाहिए, ये जिम्मेदारी है हमारी चाहे वो सीनियर लॉयर्स हों या जजेस हों या गवर्नमेंट हो, कि जो नई जनरेशन ऑफ लॉयर्स आ रही है एटलीस्ट 2-3 साल तक के लिए, देयर शुड बी क्रिएटेड अ फंड by the contribution by the senior judges and by the lawyers and by the government, that these lawyers for 1 year, 2 year, 3 years, so long they are not able to
they get stipend,
self-dependent. So they should be funded the stipend. Instead of वो चोरी सीखे कि भाई ठीक है ले जाइए 500 के 5000 मांग लीजिए ये आदमी। तो कहने का मतलब ये है कि the seniors or the superiors, they must provide for the upbringing of the new lawyers that they are on the right path. उनको ले जाएं। इंटर्नशिप में भी जो लॉयर्स के पास जाता है तो वो फाइल ही उठा के मुंशी की तरह चल देगा, जो उसके बैंक के चेक बुना के ले आएगा या उसका खाना ही गर्म करके ले आएगा। They are not, and they are cultivated this way, so they will also behave with their juniors similarly next time. तो सीनियर्स की और जुडिशरी की और गवर्नमेंट की जिम्मेदारी है कि जो प्रोफेशनल आ रहा है, जो पढ़ कर आ रहा है, अब नेशनल लॉ स्कूल से आ रहा है, यूनिवर्सिटी सिस्टम से आ रहा है, अच्छा बनकर आ रहा है, डूइंग वंडरफुल, और उसके साथ ये जब वो वहाँ देखता है कि प्रैक्टिकली क्या हो रहा है तो धक्के खाता फिर रहा है। तो वी हैव टू गार्ड देयर इंटरेस्ट। हम अच्छी एजुकेशन दें, अच्छी ट्रेनिंग दें, अच्छा सब कुछ करें, बट their professional career also in the beginning must be guarded, that they are not going haywire and they practice the law in the spirit of the law.
थैंक यू सो मच भट्टी साहब, आप आज आए और हमारे यहाँ पे बहुत लोगों को फ़ायदा होगा आपकी टॉक से, और नए बच्चों को भी few of my juniors are also there, and I know that you are coming after having a function in your college today, and you could spare a valuable time to me. I am very thankful to you. Namaskar.
It's my great pleasure. You have been a very ideal friend to me. I am always at your disposal.
Namaskar.
Thank you so much.